Hello and welcome to this session on critical thinking. My name is Amir Paz-Fuchs. When we think of critical thinking, this could be quite a daunting task to an extent. It requires quite a bit of self-reflection, partly because critical thinking applies to everything. Wherever we go, we can and are encouraged often to think critically about arts, about films we see, books we read, about the politics, society around us, about our relationships. We're always encouraged to think critically, to question matters. So we can't cover all of that here today within the confines that we have. But even when we think about legal analysis, so critical thinking within the confines of legal analysis, there's quite a lot of ground to cover. So perhaps a structure that will be helpful for us today would be through WH questions. That is the who, what, where, when, and why of critical thinking. So let's try to apply that to critical thinking today. Let's start with the who. Well, that's probably the easiest of the six that we'll have today. The who, of course, is you. The answer to the who is you. You would be expected to apply critical thinking wherever you go, and in the context that we have here, to your legal analysis. Okay, but perhaps you're not persuaded, even though it's probably been drilled within you. Perhaps we should spend some time asking why. Why should you apply critical thinking? Well, critical thinking is not only critical, some would say even crucial and important. Just formally, for example, within the UK context, you'll find that the joint statement of UK research councils from 2001 places critical thinking as one of the most important set of skills a research student needs to develop and exhibit. You'll find it way up there with validating problems and a knowledge of research advantages. The same thing can be applied and be seen in other jurisdictions. So, for example, in Australia, what Australians have called a graduate attribute, an important graduate attribute, is critical thinking, and that in the capacity for analytical and critical thinking for creative problem solving. This is from 2008. And beyond the pond, Americans, just for example, find this as part, you could find this in promotional material for American universities. One of four, right? Major draws for come to America. Why? Because you find that American universities place high regard in critical thinking. So you'll find that governments and universities and institutions place high regard in critical thinking. This is drilled down to the field level, to your committees, to your supervisors, and you'll find, for example, that when it comes to assessing student assignments, a key defining line between those that are excellent, very good, and all the rest is indeed the critical dimension. So hopefully you were persuaded that critical thinking is critical, is crucial. But how would we know that you've hit all the markers and you actually have applied critical thinking? And so unfortunately, that is a bit more complicated than one would hope, because critical thinking has quite a few definitions, and they range from the very rudimentary and basic to the more complex. At the basic level, one finds several authors referring to the dictionary definition, in which critical thinking is described as the objective analysis and evaluation of an issue in order to form a judgment. This is very much in line with the Enlightenment tradition, rational analysis, objective rather than subjective, curiosity rather than passion. It's not a bad place to start, but let me just stress that what is meant here is not that you shouldn't have passion, but that passion isn't enough. You should follow the facts, as it were. I think there could be critical thinking applied to this definition of critical thinking, but at the very least, this means that you can put in place critical thinking and present critical thinking just by a very careful and close analysis of the facts. Okay, a bit more of a contextual, higher level understanding of critical thinking suggests that this is a process that gives reasoned consideration not only to evidence, which is refers perhaps to the previous definition, but also to context, conceptualizations, methods, and criteria. Here you have a bit of a more complex definition, which takes into account context, the concepts themselves, methods, and perhaps even critical analysis of the methods themselves and critical analysis of the criteria themselves. And finally, we find that critical thinking can be seen as part of the creative process, right? A higher order skill, which includes originality, creativity, construction, inventing, devising, and the rest. So you have kind of a range of understandings of what critical thinking is about, and perhaps you can find yourself where you're comfortable within these areas. So when continuing to think about what critical thinking is about, perhaps it's useful to think about what your research is about. And one would think perhaps that critical research applies differently to different areas of law or different types of research. You don't need to stress too much about it. I find myself writing across different research types, so you don't have to pigeonhole yourself. But as a starting point, perhaps it's useful to think in those terms. So what we find is that we have the doctrinal, the law and, talk about that, this is a very, very broad church, and then the high theory type research in law. So how do we go about doing critical analysis of law, for example, when applying to doctrinal analysis of law? So for that, we need to know what doctrinal analysis of law or black letter analysis of law is. I assume that most of you probably know very well what black letter law is, but just to be clear that we're all on the same page here, black letter law or doctrinal analysis of law usually suggests that we're talking about an analysis that focuses on the statute, on text, on cases, various cases, legal doctrine, and the rest. People doing doctrinal analysis of law are considered to be less interested in what happens before or after the law. By that I mean how the law came about, issues of power, various aspects of power, or what happens with the law after it is in place, so implementation and application of the law. Those doing doctrinal analysis of law are usually less interested in legal theory as we usually understand it, but those doing legal theory associate doctrinal or black letter analysis of law with the positivist tradition, again, particular methods of analyzing the law. Perhaps it should be, because we're talking about critical thinking, perhaps it should be noted that there's a group out there that are considered to be critical theorists, crits. And those critical theorists usually tend to criticize doctrinal analysis of law for concealing the ideological, normative, political, moral elements of the law. By that, I mean that critical theorists usually suggest that doctrinal analysis of law isn't critical enough. However, strictly speaking, this isn't true, because doctrinal analysis of law can be very critical, simply not in the same way that critical theorists think of critical thinking. In particular, the reference point or the criteria that doctrinal analysis of law applies are law's internal criteria. And by that, I can refer to efficiency or fairness and consistency or coherence or transparency, and we can add more to that list. What I mean by that is that the law itself, you can find within the law itself these criteria. And when people doing doctrinal analysis of law suggest various criticism of the law. They suggest that the law isn't holding up to its own standards because these two cases are not consistent, or the law leads us down kind of a narrow path that is inefficient, and if we change the law, various decisions could be made more efficient, or it's not consistent and therefore it's not fair. It applies differently to different groups and therefore it's not fair, etc., etc. Just to give an example, perhaps one for critical analysis of law within the doctrinal paradigm, one can use this example, which I've used in the past with Professor Lindsay Sturton. So this is a true story. In 2008, the then Archbishop of Canterbury, Rowan Williams, raised controversy by suggesting that the UK ought to consider allowing Muslims to decide disputes under Sharia law by creating plural jurisdiction. This, he argued, it would reach out to people who did not identify with English law and promote social cohesion. Let's say we wanted to conduct scholarly research on the topic. What questions might we ask? So the issue here, to an extent, from a doctrinal analysis, is that to what extent can people decide to settle their disputes according to a particular body of law? So let's say, do Norwegian businessmen living in the UK decide, hey, we're comfortable with Norwegian law, we know Norwegian law, we think Norwegian law is perfectly fine, we're comfortable with that, let's make an agreement that if the dispute comes about, then the dispute will be settled in accordance to Norwegian law. But moreover, we don't trust UK law courts perhaps to apply Norwegian law as we understand it, so let's appoint someone, an arbiter, who will decide this law, who will settle the dispute for us in accordance to Norwegian law. And that's perfectly fine under what is known as private international law, or also known as conflict of laws. So what questions can we ask about this particular situation with regards to Sharia courts and Sharia law within the UK? So perhaps a few questions can be raised. For example, at the moment, even before Rowan Williams' suggestion, are decisions by Sharia courts already enforceable in UK courts as arbitration awards? Are all of them? If so, if the answer to that is yes, are all of them enforceable? Under what circumstances can we think of awards by Sharia courts to be denied or should be denied under existing English law? This is not a normative, political, moral question. Under English law, to what extent, maybe the Human Rights Act, etc., to what extent should those awards by Sharia courts be denied? This is under arbitration law. Perhaps there are other methods that could be relevant. Doctrinal analysis also employs comparative methods. So perhaps we should look at other religions, not only Islam and Sharia law, but rather other religions and other common law jurisdictions. So a possible title for this is the enforceability of Sharia court decisions under the Arbitration Act 1996. So moving on, the second category was law and here you have a very, very, like I said, a very, very broad church. Perhaps one of the most familiar is law and society, also known kind of as socio-legal methodology. So you have the Journal of Law and Society, which you find its latest edition right here. And in that context, what we're talking about is questioning the application and implementation of the law. We look at practical problems in using legal powers, effectiveness of enforcement, or impact on one or more groups of people. And in this latest edition of Law and Society, Journal of Law and Society, you find examples of all of the above. You can find about regulation to put in place a smoke-free society, coercive paternalism, questions of that nature. Yeah, you have empirical research, qualitative research in the context of what happens when computer programs do things for us, etc. You have law and speed, and to what extent, in the context of asylum appeals, and to what extent the delays of process with regards to asylum appeals impacts our sense of justice, etc. So these are all relevant questions when we talk about law and society, law and politics. These questions, it is clear, go beyond the law itself. And so you can have law and society, law and politics. You can also have law and philosophy, for example. You have here the criminal law and philosophy, the Journal for Criminal Law and Philosophy. It could be normative questions. And what is important here in all these examples is that rather than applying internal criteria, you apply here external criteria in your critical thinking, right? So you embrace, for example, philosophical criteria or behavioral economics or economic criteria or sociological criteria, and you apply that to the law. So it could be utilitarian, or it could be deontological, it could be economic, it could be sociological. And you say, okay, you have this paradigm that you think is useful as a way of governing society, of a way of thinking about society and what is just and what isn't just. And to what extent does the law take us closer to where we want to be? And if it doesn't, then how should we get there? And how should we change the law in that regard? So this is a nice example that I just came across whilst working on this presentation. We find that empirical research has suggested that the UK Disability Discrimination Act, prior to the Equality Act, worsened the employment rate of people with disabilities. This is obviously counterintuitive. We expect discrimination laws to assist those that it targets. And in fact, for various reasons, and you can look at the article, for various reasons, the UK Disability Discrimination actually, when you look at it empirically, worsened the employment rate of people with disabilities. So this is a classic type of critical thinking that is socio-legal and applies methods that are outside the laws and interested in issues outside the law and the law's application on those issues. Finally, in this regard, perhaps the highest level, but this is not an evaluative or a hierarchy, right? The highest level, one can think of an X analysis of law. And by that, one can refer to philosophical analysis of law, economic analysis of law, etc., etc. This is different from the previous category in a way that I hope will be clear. We're not talking about embracing a particular paradigm to analyze particular areas of law. We're talking about questioning concepts within the law itself. These types of paradigms, or these approaches, are heavily associated with an ideological agenda. On the right, we can mainly find the economic analysis of law, and here you find the title of the cover of Richard Posner's very famous Economic Analysis of Law tract. On the left, there's far more writing and far more varied. So we can talk about critical legal studies, and here you can find an analysis, a critical legal studies analysis of the law of trust, Marxist, feminist, Catherine McKinnon, racial, Charles Mill's book entitled The Racial Contract, which in itself is a response or continuation to Carol Pateman's book called The Sexual Contract. So what you find here is an approach that embraces a particular paradigm as a starting point and applies that to very basic questions of law itself. It could be contract, could be access, could be justice, could be equality. And here's my own contribution just recently. If I may self-plug myself, and an article that recently published titled The Legal Realist Perspective on the Law of Agency Work. So embracing legal realism when analyzing agency work. Sometimes, again, in discussion with your supervisors or committee, you should actually justify why you're using this particular paradigm. That can be helpful. Sometimes it's self-explanatory and quite obvious. So if you want to analyze domestic violence, why you're relying on feminist theory could be quite obvious. But if you're using feminist theory or critical race theory to analyze contract law or commercial law, perhaps that's less obvious and would require some justification within the thesis. So I'm kind of wrapping up and thinking more technically, perhaps, now moving on to the question of when do you need to think critically? Well, the obvious answer perhaps is always, throughout your thesis, throughout your life, but in the confines that, in the particular confines that we have here, throughout your thesis, from the get-go. John Dewey, American philosopher, spoke of critical thinking as reflection, and he spoke of pre-reflection from the start, from the point where you actually start thinking about the problem itself. Environmental issues, Brexit, discrimination, equality, that's part of the critical issue, right? Where is the mischief here? But focusing on the issue or identifying the issue isn't enough. You need to identify the question. So to what extent does the Equality Act address the current issues of gender inequality or sexual inequality? That's a question, for example. And then when you move on to construction, when analyzing construction, reconstruction, deconstruction, I found this nice sentence, nice approach to this. Analysis is putting things into boxes, critique is taking them back out again. So analysis is part of the way there. You need to identify the boxes and how the issues that you're dealing with fit into the existing boxes, but then perhaps you need to take the issues out of the boxes and perhaps create your own boxes. And that's where critical thinking comes in. When arguing, you will obviously come across various arguments on 2 or 3 or 4 sides of the argument. Find your own voice, right? At the undergraduate level, it's enough perhaps to identify the various arguments. You need to come off the fence. You need to be critical about the arguments that you're presenting. Sometimes it's just enough to say, I agree more with X rather than Y, with Smith rather than Jones for these reasons. Sometimes it's actually better to say, actually, I don't agree with either of them, but I'm going to take bits from both, etc. And finally, the reason this kind of goes round and round is because you will need to be critical about yourself, right? Maybe the issues that you've come across when you're presented with the facts, presented with the arguments, you need to go back to the problem in the question and rephrase it and address it anew, because maybe you're asking the wrong question. After you've gone through the analysis and the construction and deconstruction, maybe you find that you're asking the wrong question or barking up the wrong tree. Don't shy away from doing that, from criticizing yourself. To summarize, where do you integrate critical thinking in your thesis? Well, again, it's pretty much throughout, in the basics, in finding the mischief, asking the right question, following the facts, in the analysis, when you posit arguments against each other, when you make your own arguments, where you apply criteria, whether it's internal criteria, external criteria to support your arguments, when you question the criteria itself. And finally, when you're able to question basic concepts or doctrine, when you reevaluate what is contract, what is the reasonable man, what is access to justice, what is access, what is justice, equality, etc. I hope this has been helpful, and take good care and good luck.